I don't have an alert for this, but I'm pretty sure that we're on YouTube. Maybe I should have
YouTube.
an alert. Do you have an alert, Matt?
It says live on YouTube right there on the screen, Ray.
It does.
Where I says
Right
it
here.
right on the screen.
Right here. It says it right, literally right here.
Right. Hold on a second. Let me wait. Can't your arm's in the way.
It says meeting is now streaming live on the YouTubes.
On the YouTubes. I'm a YouTube premium member, so I'm spending money for no apparent reason.
I may be forced to join just because when I put the baby videos on,
Commercials.
there's sometimes commercials every 2 minutes, and all I
Right.
hear is him yelling, "No, not that one! No, not that one! I want my movies." When there's a commercial, and
No
it's
way.
almost what's that?
No way. He's like a spitting image of you.
Oh,
He's like, I'm not going to take this.
yeah.
His
No,
mother
not
must be
that one.
impatient.
This one.
He must have an impatient mom. That doesn't sound like anybody I know.
Yeah, I know. His mom has passed on some really bad habits. It's my job to coax them out, right?
When we last left our two viewers, you were just about to talk about item number 2.
Are you talking
Remember
about
what
last
that was?
week?
Do you remember what that was, Matt? We had talked about Kyle Rittenhouse and his defenses and his apparently case law, black letter law defenses that he had.
I thought we went over the Kyle Rittenhouse defense.
Oh, no, we did. We did. We were moving on. We were moving on to the next thing, and then we got canceled, like you do in society when you say things that are rude. We got canceled, and now we're back to item number 2.
Ray, would you like me to look that list up? I actually I committed those, I think, to Twitter. I can look that up.
I will hold on. I will go to Matt Heiduch's Twitter account.
I mean, there's plenty to talk about. You guys want to talk about this Mitchell Trubisky deal? Woof. We're
Well,
stuck
I don't know
with this guy.
what happened there. That sounds like a Chicago Bears quarterback.
It sounds like we're stuck with this guy, Ray.
Yeah, I
Well,
don't think so.
He's a great quarterback. Why would you say such a thing?
Ugh.
Where has
Have
he
you
been a
ever
great
tried to
quarterback?
throw a football as far as he could throw it? Have either of you thrown a 60-yard football?
Okay, Uncle Rico.
With a Nerf or a youth football, maybe. Not anymore.
I wonder how close I could get to 60 yards. I'm out of shape though, but
I think you're missing the whole point, Ray.
there was
which
a
is
time.
like,
There was a time that I could launch the old launch it. Go ahead. I'm
oh
missing
man,
the point.
number two was Lawyer
Lawyer
Cat,
Cat.
which I don't think we have to talk about because that's been beaten to death. But
Well, we did talk about Lawyer Cat because we, at the end of the thing, I became, I think, Lawyer Pig or Lawyer Dog.
did you guys read the follow-up to that where somebody has traced that image to something that was distributed in a chat program on like a 2005 Dell?
No.
When you look into it, everybody was trying to say, how do I become the Lawyer Cat? Nobody could do it. And then somebody did this research, and it turns out that this image was part of a chat program that was distributed like 15 years ago, leading people to believe that this guy is on a computer or had moved stuff over from a computer that's
Exactly,
like beyond
Pat.
ancient. What's that?
I said exactly, Pat.
Lawyer Cat. So this dude's using a 2005 Dell. Good for him.
Yeah, and apparently his story was when he was on, and when he went to court, it just flipped on, and then you saw the interaction, and then apparently it just turned off again. Like there's some glitch with this guy's old computer. I mean,
It's
it was
hard
a
to-
beautiful story.
Hard to believe that there would be bugs like that in a 16-year-old personal computer.
Coming from the guy who can't run the virtual background, you're gonna judge, Pat?
I can. I don't have the equipment.
I can, but
That's
I
not a
don't have-
glitch. I can run it. It just doesn't look good.
Here, hold on
That's
a
not a
second.
bug. That's a feature, Matt. That's not a bug. It's a feature.
I have all my tabs open, but I'm going to show you guys. I found the article. Texas. Oh, it's not. It's behind a paywall. But Texas lawyer Rod Ponton's accidental Zoom cat filter likely due to an aging desktop, says Dell Technologies. And it sounds
So,
like,
so he gets on the thing and then he like claims, he like starts to exclaim that he's not a cat.
You haven't seen
yeah,
it?
I haven't
Ray,
seen
let me share the screen here.
Oh,
I have not seen it, but the thing
You haven't,
is
wait a minute, you haven't seen the Lawyer Cat?
I have not seen Lawyer Cat.
Ray, we have to watch this. Now, the best part is, I'll show you this image.
Okay.
The best part is like, this guy's about to do a hearing and the judge says, so this is him. This is him in the lower right. So the judge is like, yeah, there's a filter or something turned on. And the guy says, I'm not a cat, judge, and I'm ready to go with the hearing. Like, just like he's ready to go. Here it is. Let me see if the video is linked here. But basically, this article says that people have tried to do what happened in this video and they couldn't do it, and then they've gone out of their way to try to figure out where this image came from, and it's a Dell that's over 10 years old. All right, I think this is it.
Okay. Well, it's short.
Can you hear it?
No, you got to share the video. When you flip it over, you also have to
Yeah,
share
I'll do it
video.
again. Hang on. I didn't know we were doing.
There's
video
a
sharing
box
today.
that you have to check in the menu in order to share the video.
I think it's a filter,
There you go.
Mr. Ponton. I believe you have a filter turned on in the video settings. You might want to take a
We're
look.
trying to, can you hear me, Judge?
I can hear you. I think it's a filter.
It
And the-
is, and I don't know how to remove it. I've got my assistant here. She's trying to, but I'm prepared to go forward with it. I'm here live. I'm not a cat.
I can see that. I think if you click the up arrow next to the
Ray, he's there live and he's not a cat.
Not a cat.
I am here live, and I am not a cat.
that cat's no
We're talking
cat,
about Lawyer
man.
Cat, bro.
Did you notice that Jerry, who is I guess the other attorney, he doesn't even look at the screen while they're having this discussion until the last 3 seconds.
Well,
Ray-
my favorite part about that whole thing is that little meek, mild voice that's coming. I'm here. I'm live. I'm not a cat.
Do you know how you know a man's a pro?
Go
Okay,
ahead.
how?
When his old computer turns on the cat filter and he's still ready.
He's still
That's how
ready.
you know that man's a pro.
Well,
It's like
that is the true measure. It's like no matter what happens, the judge says you're ready, and you go, I'm ready.
That guy
I'm
is
not a
thinking to
cat.
himself,
I'm
This
not a
isn't my
cat, and I am
problem.
ready.
this isn't my problem. This is your problem. That's
Well,
what that guy's thinking.
I got to think if I'm doing a Zoom hearing, and I've only done a couple of them, but if somebody's there with just a picture of a cat, I like how that's going to go. I like that's how that's going to go for the day. If your opponent says, "Hey, I'm not a cat," I think you're starting. I think you're starting with it with one foot up.
I can assure you, I'm not a cat.
I love the way that older lawyers, they're always, my assistant is looking at it to try to figure out how to turn it off. You're like, okay, I get it. You still have a fax machine and you have a flip phone. I got it. I
And
understand.
I was wondering about that. Like, it seems to me the younger judges are doing really well with Zoom, and some of the older ones. Like, is Zoom court going to be the end of a bunch of people in this profession? People who are kind of hanging on to hang on. Like, do you think this is going to be where some of this older
Well,
generation?
don't you? I mean, and I am happy to bring this up right now. Our very own Matt Hyduke has a theory about the way that court is going to develop in the next 10 years. And he feels like it administratively, things are going to be handled administratively and, through algorithms, and they're not going to go to hearings and expensive affairs. They're going to boil things down to pay your ticket, Pay your ticket. Well, it's like, we almost have it with our court. Pay your ticket, you pay $1.60, right? If you don't pay the ticket and you come to court, if you lose, it's like $400, right?
I don't know that I think that, but what I think is, and this isn't a technology thing necessarily, it is a money thing, that as we start to cut court costs and sort of think about just how punishing we've been through administrative fees and how crazy stuff is, I think some of these villages and local police departments are going to try to figure out ways to get money. And I think a lot of stuff is going to get decriminalized and run through these municipal kangaroo courts where there are no rules. And I think that's going to happen. I don't think algorithms are going to run it. I think money's going to drive it. And I think as the money, I think we talked about this before, at least Ray, you and I talked about it privately. I think up until 2010, we were still riding the end of the Reagan war on drugs, pump federal money into local police department era. I think that that's been dying a slow death that's being accelerated now. And I think that those departments and municipalities are going to look to recapture that money. And one of the ways they're going to do it is to basically decriminalize stuff, but run it through municipal courts. And I think that's going to be the next wave of this.
Pat, do you get out to municipal courts at all? I know that you're super busy doing but I mean you personally.
Probably 5-6 times a year.
Are you just stunned when you see how horrible the system is out in the city courts? I mean, I went to a city court where the evidence wasn't lacking. To call the evidence lacking would have been to upgrade the evidence that we heard. It was conjecture, third-party rumor, okay? And I sit there and I listen to an administrative law judge, and he's like, well, they said it. I'm fighting for the city. And you're like, what just happened? And the thing I
ran one in McHenry where they didn't have the officer who made the arrest or ordered the tow. They didn't have any of the tow paperwork. They had somebody who was on shift who talked to the officer, and the officer told him what the whole situation was. And this guy thinks he may have seen the paperwork at some point. And the administrative law judge in McHenry said, yeah, I'm good with that.
See, isn't this the future, Pat? If you can send a case to county court and get a tenth or a third or even half of the money, but might have to call your cop in, might have to pay him overtime, might have to do that, or you can just do this garbage where you're going to let one guy show up on all the cases and read reports and get all the money. Doesn't that seem like that's the direction like misdemeanor court is going to go?
I don't know about misdemeanor court. I don't know that you can do that with anything that impacts a right.
Yeah, but this is what Matt's saying. They withdraw those rights. They say, oh, yeah, you have the right to this when you are going to go to jail. So they go, okay, no jail. Then they go, you have the right to this when you don't have X. And they go, okay, no X. They're trying to cut it back to you pay money, goodbye.
Here's a perfect example. You guys, you want to go back 10 or 15 years? How many bar fights did you guys get compared to now? So for me, it was a lot more. I don't know when I got two guys tussling at a bar last, walked into my office. You guys do higher volume of that stuff. Maybe you're seeing it more, but I used to see that a lot. And what I think is happening now is the cops show up, there's a bar fight, rather than petition or hit two guys with complaints or pick a side, they're giving both those guys municipal tickets. Those guys are walking into muni court and paying $150 or $200 a pop. They have to put no resources into it, and it's done and it's over. Are those guys catching criminal convictions for batteries? No, but why does the municipality care? Right? They don't have to put any effort into it. And I think that was happening with cannabis, with drug paraphernalia, with all your kind of, out of the box misdemeanors. And I think it's only going to get more prevalent.
I think all you need, I think what would stop that is you would just need a mayor coming in saying, I'm running against Matt Flavin for mayor, and Matt Flavin is not prosecuting any criminal offenses. He's letting people off with a slap on the wrist for bar fights, for drunken disorderlies. He's for possession of alcohol by minors. He's doing that. John Q. Public's not going to know the difference. And if they, all you need to do is put something up and saying, well, here's the number of misdemeanors that haven't been prosecuted under his term. And I think you would stop, at least out here.
And you know what I do then? I go to the village board and I go to the chief of police and I say, this guy who's running against me wants to take this much money out of your bottom line. How do your cops feel if you've, or what happens with your union contract if you've got to let somebody go? Village board, have you guys thought about a way to make up this money that's going away? And that's how I would deal with it, because the reality is it's about money. And then I'm coming out publicly and saying, no, I'm not letting these people off. I'm keeping it local where we have control. When I send stuff to the state attorney, I don't know what they're going to do. And sometimes they drop cases without asking me, but I know that's not happening here. Since we've started doing this, we've convicted every single person.
Yeah, I was going to say, since we started doing this, we've convicted every single one, but it's not 100%. A conviction. They find them liable. That's how they do it in municipal court. They find them liable. But I had a case.
I get
this
it.
This
and
is
the village board will get it. I don't know that the public, the voting public, would get it.
But I think minimum, Pat, don't you think it's slowly been going that way the last 10 years anyways, and nobody seems to care?
It did. It did when they could get away with suspending licenses for cannabis, kids in cannabis and kids in booze. They took that away unless you're driving. I don't know now.
Well, the thing, here's what happened. This is a case that I had. It's a couple years back, but it makes the point. The minimum fine for a kid drinking alcohol, a minor possession of alcohol or minor consumption of alcohol, is $500. Okay. So the fact pattern is this: there's these kids driving in a van into town. They get pulled over for speeding. When the van gets pulled over, there's 7 teenagers in the car.
Oh no.
In the middle, there's the driver in the driver's seat, the passenger in the passenger seat, and then the back of it is like, it doesn't have any seats in it, and they're all kind of sitting around a campfire in the back, right? In the middle of the campfire is a can of beer. They charged all 7 people with possession of the same beer and charged them all $500 a pop. So with one stop, they made $3,500.
And back then, yeah, you could walk in and you would say, all right, hey, let's amend it to something that's not going to suspend his license.
Well, it doesn't suspend their license when it's ordinance.
Yeah. Oh, yes, it does.
Well, no, at this time it did.
Some of them reported to the Secretary of State, or some of them did. Starting in January 1st, none of it, the alcohol, it doesn't suspend them. My concern is, if I was the village, where's your teeth now?
They got
how do you collect
$500.
it? Right. How do you collect it?
But I think the issue there is, even if you're going to collect a lower percentage, the resources dedicated to that are nothing. They're absolutely nothing. Where in state court, you still have the collection problem. You're not paying for the collection, but you still have that issue. And I think there's another layer to this that is going to be blowing up, that's already blown up, which is like the vehicle forfeiture nonsense now, where you get arrested for a DUI and they say you have to post a $500 bond on this vehicle forfeiture. Then you don't show up because you can't beat it and they keep your $500. What's to stop them from doing that forfeiture in anything related to a car? For example, speeding. Why can't you tack on a $150 vehicle forfeiture on a speeding? Oh, I popped you for speeding. Here's your ticket. You got to go to municipal court, and I'm taking your vehicle right now unless you post a $150 bond. I don't think there's anything preventing them from doing that, and I think that's a really easy way to just start sucking money out of the system. And that, getting back to Ray's original point, that's what I think the future of this is. It's basically a bunch of taxes that lead up to something you can't win. And that's not going to happen in real court where we, are there all the time and have rights and stuff. They just can't.
No, I don't know. I don't know. We'll see. Red light cameras had a pretty good run. It might be that they might do that for a while.
Wasn't that hilarious? That was just amazing.
You know what the issue with the red light cameras was, right?
I know what the issue was for me. The issue was you're going to write a red light camera. It's $10. It's $15. It's not $200 a pop, because when they automate them, the light on Route 120 going out of McHenry, Lakemore, the light at Lakemore made $1.2 million. That light.
Yeah.
One light made $1.2 million. I was like this. How come I don't have a red light camera? How come I don't have a red light with a camera on it? That's a year.
There's one in Barrington off of 14 and 22.
22. Yeah.
I personally have given that goddamn thing $500.
So I read this and I'm trying to find what happened. And in Kane County, there was a big article that ran when they were removing the last one or second to last one in the county. I'm not sure there are any left in Kane County. I know there's one still in DuPage. And there was an article in the local paper that said basically the problem with the cameras was there was zero increase in safety as a result of the cameras, absolutely none. And the way it worked is you are, as a municipality, paying rent to the company who puts that in, who cuts you back 50% of the money. And on whole, they really weren't raising money. So you had a lot of problems where you're angering your local citizens. You were not increasing safety by numbers, and it was oftentimes a losing or a break-even proposition. I mean, I don't think it has. I honestly think the money is the biggest thing. You've got people putting a little pressure on the local municipalities, and then you're really not raising a ton of money.
Well, the thing is that they write, as Pat said, Pat paid 5 tickets out at that spot. You know what the next election is. Hi, I'm mayor. Are you a little sick of the red light cameras?
Yeah.
Yeah.
If you're sick of the red light cameras, vote for me. If you're not, hey, vote for the other guy. His name is Red Light Rick. You vote for that guy.
I do not want to in any way have this come off as disparaging towards Pat, because we all know I would never do that. However, I got a red light camera ticket once and said, there's a damn camera there. And what I did is every time I rolled up to that camera, I made sure I stopped. So it had a deterrent effect, but they got me once, right? They didn't get me 4 or 5 times.
No, but I thought that the story was going to go like this. They have a camera there. So I subpoenaed all of the photos from all of the thing that
No, I remember I got stopped at this camera. I get the ticket like 2 weeks later. I'm like, there's no way I didn't stop. And then I watched the video and I was like, all right, I didn't stop. And then of course I loaned my truck to somebody 2 weeks later and he got popped at the same one and I got yelled at because it's what'd you roll through that for again? But
and that was over the course, like I said, I used to go down there when my mom was around, and that was over the course of 4 or 5 years. And I thought it did have a deterrent effect. And I did the same thing. Every time I'd go on that video, I'm like, I know it's there. I know it's there. Of course I stopped. God damn it, I didn't stop. I fought one.
Did you win?
No, God, no.
He's like this.
No.
God, no.
But did you hurt him, Pat? Did you hurt him?
One I beat because they didn't have they lost the video. There was no video clip.
It seems like it's hard to go forward without that video, doesn't
Sometimes
it,
in
Pat?
what we do, hurting them enough that they don't want to rematch is a win, right?
Oh,
That goes in the
I
dummy
paid for
account?
glass
That goes in the
cleaner
dummy
on the camera.
Yeah, like it's like a boxing match where the guy who wins doesn't want the rematch. That's a win for the loser. Let's be real.
Speaking of automated nonsense, what was the verdict in that Zoom trial?
I had completely forgotten about that. Ray, to refresh your memory, the very brave civil trial lawyers in Lake County were bragging about how they were going to do a jury on Zoom, and they were going to pick a jury on Zoom. What's that?
Okay.
These very, very brave people were going to do this. Of course, I'm being sarcastic, and I never followed up. That was supposed to happen, I thought, Wednesday, wasn't it?
Yeah, the only thing I could see, and that's why my
I was thinking this. So their malpractice carrier, they made sure and checked that out with them, right? Before they did that? Because I mean, and I hate it when people say this. Whenever anybody says, well, that's malpractice per se to do something. Whenever anybody says that about the practice of law, I'm like, it infuriates me because I think that there's a wide ability to practice in a lot of different ways and to use different things, different ways to make your point. And it's an art, it's not a science. But that being said, yeah, it seems to me like you would talk to your carrier before you did something like this.
I did hear something. One of the participants, his video kept freezing.
Oh man, we're gonna be behind a paywall. I think this is a joke. I'm not interested in how this goes. I can't see anybody who thinks that they are a competent attorney who can reach out to people. I can't see anybody wanting to do this. I can only see lawyers wanting to do this for the novelty, for being able to say I was first, or to be honest, because they're scared to stand on their feet in front of 30 people they don't know, or give an opening in front of 12 people they don't know. And it can be terrifying, but I can't see a reason other than those 3 reasons somebody would want to do this. Unless you've got a loser case. And you're just
Okay,
like,
and I mean, I guess that people are scared of whatever they're scared of, but the problem with being terrified is I am sure 28 years ago, when I picked my first jury, that I was somewhat scared with the whole thing. But that boat has sailed many, 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 many times.
it's just talking to people, right, Ray? You're just talking to people.
Well, and you have an idea and you're sharing ideas. I have an
Right.
idea. I have questions.
I can imagine. I don't know how you guys are. To me, the worst part of a trial is watching the state do a close. I mean, the worst part is after you've done your close and they get rebuttal on your.
That is the worst part. That is the worst part.
But the worst part, which you get to respond to, is watching them do their close. Like the walk up, for me to just try to not start talking before I hit that podium and kind of look professional because I'm so ready to go. And imagining what it must be like to watch somebody do a Zoom trial and not get to just stand in front of those people who you picked and look them in the eye and relate to jury selection. And you're looking at this guy and he said he's a foreman at a factory and you make sure everybody follows the rules, and you're saying, like, just like you at your job, making sure everybody's following the rules. Like, I can't, how could you think this Zoom trial is anything but a mockery of what we do when you don't get to have that interaction with people?
Well, there's that new waiver we have to sign now. I think that came out. It might have come out when we met last time. I think it was Thursday. If it's a substantive proceeding, there's a waiver. I think there's one on the clerk's website that you can get, that even simple things we're running into where the client is in front of the judge. The judge can ask him the 4 things on the waiver. The judge will not do that. We've had to come back for motions to modify bond, things like that. I don't know. I mean, the Supreme Court has said this has to happen for anything. You have to waive it. I think from on our side of the building, it's real simple. No, I'm not waiving it. For now. But this, I told you guys, I did a shelter care hearing via Zoom, and people, it could not have been more obvious that people were doing 3 things at one time. You got the state's attorney over there when you're asking questions, reaching over and.
A shelter care hearing is basically a formality. I don't want to guess your lifetime success rate at those, but I'm guessing it's, the number of those where you've won is pretty low. Like, those are, in the eyes of the judges, oftentimes a foregone conclusion, right?
100%.
And you didn't like that experience there. And now we're talking about a trial where you have to connect with people you don't know. you know, from a lawyer perspective, like forget the mechanics. They could be talking to people. Like, I don't want to practice law like that. Do you? I'm here because I like talking to people off like Max Headroom.
There's two reasons. There's two reasons you're going to do a trial. Number one, you think you can win. You think you got a decent case. Number two, you have to. And either way, you as the attorney, your client, you have a right to have that happen in a forum where you can connect with people, where people are giving it 100% of their attention. Even though, I mean, we both know that people zone out when you're in person, but you can do things to draw them back if you're in person, right? If you've got ESPN on just behind your camera and you're watching the Sports Center and you're watching the ticker, or your kids are running around in the background, or your dog's got to go out, and you're distracted by everyday home things. That's an injustice. That's the understatement of the week. I mean, to me, it's a sacred thing, whether it's a civil trial or a criminal trial, and you should be entitled to have every aspect of every thread of a chance of an opportunity to win. And that absolutely takes away so much of it. And so much of what we do, like you say, we're talking to people. It's that one comment that you make in voir dire that, okay, you connected with that guy and that woman liked it and these people laughed, and now you've put them at ease, and maybe the other side's got them on edge.
Yeah. And that's somebody sneezes or coughs and you hit them with a bless you like mid-sentence. But I know enough about you guys, like Ray, Pat. If it wasn't for this, we wouldn't be engineers, probably. We weren't going to be chemists. We weren't going to be, I know Ray tried to do the medical thing, but for the most part, guys who do what we do, ladies and guys who do what we do, aren't cut out to do things that aren't interactive with people. And it's part of the skill. And that's why when I see this Lake County thing, I'm thinking, who are these lawyers? Unless the judge comes to you and says, let's take some garbage to trial, right? Like if the judge is like, I want to try this. Do you guys have a garbage case we can do? Which I understand, but I don't understand how anybody who considers themselves a trial attorney, even on the civil side, where trial attorneys don't try cases, thinks that this is a good idea. Like you have to, maybe I'm overconfident. You have to lack the confidence that I think it takes to be successful at this job in order to want to do a trial over Zoom.
Well, I've got a friend of a friend of a friend. We were at a 1,000 years ago when you could go to a party and talk to people. I hadn't seen this person in years and years and years. They'd gone to law school. They were in a big firm out east, and their card said litigator. Okay. We get to talking and, talking about jury trials and this and that. And, it was summer. How many have you done? In, June or July, it had been 7, 10, whatever. And she's like, how long have you been practicing? I was like, oh, did you mean like forever? Yes. Oh, forever. I couldn't even tell you. Hundreds. I said, well, I know you guys don't do them very often, but this person had been practicing at that point for several years. Well, I haven't done like an actual jury. We do motions and stuff like that. Like, oh.
Yeah, but I lose those motions, Pat. Then I have to do the jury trial.
But on the business card, they want litigator. Okay.
After I lose those motions, then I have to do a jury trial.
So that's talk about war.
They've been
stories.
zero trials in 10 years.
3 weeks ago, I get a call for somebody who wants to go into juvenile court, and I show up and they have a handwritten card from a cop that says it's for a detention hearing. And I'm like, there's no way that this is a detention hearing. Did I tell you this, Pat? There's no way this is a detention hearing. So I show up and I'm like, I'm here on a first appearance. We're going to enter our thing and get out. And she's like, well, what are we doing about the detention hearing? And I'm like, this is not a detention hearing. And she says, yeah, I told the cop to tell him it's a detention hearing. And I'm like, I've read the statute and I don't think that that's how this works. And she says, well, we're going to do what's called a walk-in detention hearing. And I remember sitting there thinking, like, I got two options now. I can tell these people we can leave, and then they can go try to pick this kid up and drag him back, and we can have a detention hearing. Or we can just stand there and we can do this now. And of course, I chose the only thing we could do. But I was talking to a civil attorney, who we won't name, about that. And it was like, this was mind-blowing that I would be forced to just be on the spot and actually have to argue in front of a judge. And obviously you guys know that's unfortunately part and parcel of our job. And it's the part of the job I hate. So when you're telling me this story, Pat, about, this lady who's saying she has to argue motions, my first thought is, oh, and you probably get proper notice and time to prepare for those motions too. And I'll try not to talk down upon her, because that would be a luxury that we're not afforded a lot of times. But I just still, I can't crawl into the mind of somebody who wants to do a Zoom trial or wants to be a litigator who doesn't do trial, because it's just like, man, so much of what makes this job special is just being there on your feet, punching and counter punching. And you're not doing that on Zoom. You're not doing it on Zoom.
No. And I'll tell you what, man, it was not, I mean, part of it, I was, day 6 of what should have been a 14-day hiatus. So I wasn't, but I just don't feel you don't feel as sharp arguing to your computer screen as you do when the person you have to convince is, feet from you.
I did my second hearing that had a person who was on Zoom, and it's difficult. The problem is that when you're trying to get a witness to answer your questions, it adds one more layer to the evasive witness. First of all, the evasive witness could say, hey, I don't understand you. Then they could say, could you ask the question again? Or what does this mean? Or they could give you a conclusion every time you ask just for a fact that happened. If you add the layer of Zoom, like, what was that? I can't hear you. Talking, it adds another layer to us getting through the hearing. So it makes the hearings longer.
You know, it's funny you say that, Ray. My favorite thing to do in court when you've got a witness who's just like not answering the questions. And I read about this in a book and I tried it. And I'm like, holy smokes. And now I do it so often. I do it so often that I don't even think about it, including in my personal life, which is not good, is when you get a guy and you've asked him a question and he wanders somewhere and you try to bring him back, either ask the same question or whatever. Like the second or third time he's doing that, if you look at that person and you point at him or you do this, they instinctively stop immediately. And it's a good way to stop a witness who's not complying or non-responsive without having to like do this. I hate people who tattle on the judge. Judge, tell them to answer the question. So it's a good way to stop a witness in their tracks, right? Just a nonverbal thing. But it doesn't come off on Zoom the same way. And it definitely doesn't come off on Zoom if, like Pat says, somebody's attention is directed 3 or 4 or 7 different ways. And are they going to come up with like an emoji you can put on the screen in Zoom or something? I don't know. But, your point, Ray, that it adds kind of a layer to get through these trials. I think that people who think we're not decent at, in Pat's case, maybe slowing things down, or in Ray's case, maybe speeding things up to expedite them, but controlling getting through this without extraneous garbage. People don't recognize that as an important part of this process. I think are missing kind of the essence of a trial, which a lot of times part of it is the questions you're asking, but a lot of those credibility determinations are based on like this other stuff, which is just going to be exacerbated because you can't use the same kind of nonverbal things to control stuff.
Well, and that's one of the things that I, when we had that June 1st, right? Instead of sending them into a deliberation room where you have, the 12 angry people. Well, you can't say 12 angry men anymore. When they're in a deliberation room, it's hard to not come to a resolution of a dispute when you're across the table from somebody or right next to you or something like that, right? We leave the courtroom and they use that entire courtroom as their deliberation room. Now you got guys 50, 60, 30, 10, whatever feet away. There's no sense of urgency because you can argue with somebody across a room all day long. You get in their physical proximity, somebody, one side or the other is going to be uncomfortable enough with that it's going to change.
It's funny. It's funny you say that because when you look at how they design rooms for police interrogations, which is
right,
not a lot of
exactly.
stuff on the wall, and you put people in a position where they're forced to kind of interact, and you look at a jury deliberation room. I hate to say this, maybe sometimes you got a window, maybe you got a whiteboard, but for the most part, there's not a lot of stuff in there, and like there's not a lot of room in there. And like to your point, Pat, there's not a lot of area for somebody to go hide in a corner and get away from somebody they don't like. It forces interaction with people. And I think psychologically probably forces people to come to some kind of agreement or consensus. And when you eliminate that, like in your case, which was a hung jury, like that's a really good point. You got people who are behind a pillar 50 feet across who aren't even required to look at the person they're talking to.
No.
It's going to be interesting to see if the Zoom sticks around. I suspect that if it does, we're going to have a lot of studies 5 and 10 years up the road that says that this is just a bad way to do things. But
I think to Ray's point too, I think, you have a witness who's dug their heels in. There's a lot of things you can do in person to make that witness uncomfortable to the point where they're going to answer your question. It can be something as simple as, I'm going to walk 5 feet closer to you now, and I'm going to ask you that same thing. And I may do patronizing hand gestures. You may point, you may stop them. There's all kinds of things that you can do.
I can already hear a state's attorney saying, or I can hear a state's attorney saying, Judge, Mr. Walsh has already asked him that question 3 times. It's asked and answered. And Pat going, it's asked, but it hasn't been answered, Judge, as you're doing this.
I've asked it. She's right. I've asked it 3 times. I'm still waiting on an answer. I'll do it 4 if I have to.
I'll do it by.
But Zoom adds an extra, that sometimes it could be hundreds of thousands of miles of insulation from that.
To be fair, okay, I think that we're missing a super advantage of Zoom. And the super advantage of Zoom is, why aren't we doing all the routine stuff? Why aren't we doing all the get a dates on Zoom?
I was going to say, Ray, I mean, Zoom is awesome and can be used well, but not for trials. I mean,
right.
Like here's what I would do if I was running a police department. I arrest you. Okay, forget what the rules say. I give you a court date like, I don't know, 8 months up the road that's set for trial, and I say check in with the court in 45 days over Zoom, right? Like there's a lot of ways to use Zoom to make things move along better.
I think that what you just said, there probably is a way to do it so that you change the way that you proceed through a court, because the routine matters, the trading of information. You can Zoom it, you can Google Drive, or you can OneDrive it, or you can get the information to one another easily. You can email back and forth. These court dates are 1890s.
No, but this has been my gripe the whole time. You're not taking a system saying, let's design a system for this. You're taking this and you're overlaying it to a 300-year-old system saying, let's make a slight modification, right? That's the problem. If you were going to redesign a system from the ground up using Zoom, it wouldn't look anything like this. And the legal system doesn't operate like that.
What one main thing you're not taking into consideration doing it, here's your trial date in 8 months, or here's this, you're taking away their biggest weapon for a guilty plea, and that's the inconvenience.
Oh yeah,
hardship on your life.
Yeah.
They'll never do that.
If I keep coming, I'm going to lose my job. How often do you guys hear that? I don't want to take this plea, but I can't come 6 more times.
Right.
Daily.
It's
so that's why
it's like that. If they got rid of the perp walk, then the feds would be like, what's the fun of our job?
Right.
So, and let me ask you guys a question, because this is something I just thought of. I did a jury 2019, I think, and it was a major jury, a major trial. and I had this experience, and I'll ask you guys, have either of you guys ever had a juror get dismissed because they were maybe drunk, maybe under the influence, maybe sick, or just not quite, like the judge got the impression they're not quite there? Because I had a lady kicked off a murder jury who walked into the pillar in the courtroom and then was falling asleep and then was walking erratically. And I kind of brought it up to the judge. And then one of the other jurors reported that maybe she had had some problems falling in the parking lot. And I don't know if you guys ever had that experience, but that's not coming across on Zoom, because every
It's
time that
not.
person fires up the Zoom, they're sitting in their den or whatever.
Yeah, you're not going to catch that.
Yeah.
I mean, how do we know these people aren't drinking alcohol while this is going on?
Well, then you have the converse of that. Why wouldn't these people be drinking alcohol if they have to listen to that?
No, I've had them dismissed for, just being disgruntled or mumbling during one side or the other's questions. And I've never. I don't think I have. Now that I think about it, I don't think I've had them.
I haven't had an impaired person that was obviously impaired. I haven't had that, or somebody that somebody felt was intoxicated. I haven't had that.
I've certainly had several that appeared to have had a fun time the night before.
Yeah.
And I have smelled it, smelled the faint odor of an alcoholic beverage emanating from somebody's breath in the jury pool. But yeah, that's true. That's true. Yeah. I'm drinking out of my Yeti. Is this water?
What was our item number 3? Or what, do we get to 2 or 3, or what was the?
Let me find out.
4 would be, what kind of mess are we looking at when speedy trial rights come back?
Oh, yeah. This is my favorite.
How many did you have, Matt?
I think it was 4, Ray.
Yeah,
we're going to have no problem because we've continued to do trials the whole time.
Ray, like, I thought this through, man. I don't know how you guys are operating. My caseload is very near an all-time high and not getting smaller anytime soon. And I thought about this, man. Pat and I talked about it in the hallway. The Supreme Court's going to give us our speedy trial right back at some point. How do they undo this mess? Because when they start doing trials, like, there's a bomb dropping, and that bomb is more cases dropping right on the state's head.
They're
right?
going to undo it. They're going to undo it like this. This is exactly what they're going to do. Anybody charged from this day forward has a right to a speedy trial.
But okay.
Anybody up to this point doesn't have that right.
But what you've done now is you've bumped ahead of the line a bunch of people with really serious cases, and now possibly cause federal constitutional speedy trial problems, because there's not a hard and fast deadline on that. There's a very fuzzy thing. You've just created a huge opportunity for defense attorneys to argue, at least, on every one of these other cases.
But I understand that. But I think that's how they're going to resolve it, because they're going to get stuck, because you're going to have Bob, who's been in custody for 4 months, and if you're really messed over no matter which way you go. If we have all the old Bobs or Marys, we have all the old Bobs that have dates, so speedy trial starts, and now you're going to try all those. That blocks all your new Bobs. Okay, you could do it that way. Or you could say, old Bobs roll, new Bobs, you have the limits, you can assert those. Doesn't matter, that causes your new Bobs to cancel out your old Bobs. I mean, you're going to have the same sort of problem.
I think, and I thought about this after we talked about it, Matt. I think if you're a little more confident in coming back anytime in the near future than I am. I have zero confidence.
No, I think.
Why do you feel like that, Pat?
I think Ray's wrong. I think they're going to say your speedy trial right starts December 1, 2024. That's what I think they're going to say.
Well, they could say that, or what I thought of after we talked about it is, if it comes back, you can assert it on the day it comes back, and it's not 160 anymore. It's 360 days.
how do they come off though? I don't think they can change it, right? And I thought about that too, because it's like they could just start tweaking it, but it's a
If
statutory
they took it, if they took it away, they can modify it. Because
Yeah,
they
but
have-
he's talking about he's not talking about the state claim. He's talking about
no,
under the Constitution where it's defined as that took too long.
I think I was talking about the state one there, but you know, I keep telling myself they can't do this, but on the other hand, they're making their own rules and they're the ones who decide whether or not they can make the rules. I think if you want to guess this based on what happened in the past, let's go back to the first speedy trial order that you guys and I tore apart because it was vague and it was stupid. Then there was a second speedy trial order that was just as vague. And then 2 days later, if you remember, they clarified it. I think what's going to happen is they're not asking any one of us or anybody like us. They're just going to say vaguely, the speedy trial right is now instituted as of this day. Everybody starts at 0. The state's attorneys are going to bark at them and say, wait a minute, we have 4 times as many trials now as we had then. You can't just do this. And then I think we're going to get another clarification
did
order
not.
2 days later. I don't know what it's going to say, but that's how I think this is going to go down.
I think
Melissa.
if you take it, if you say there it doesn't exist in contrary to the statute, I think you can say we're modifying the statute the same as we did when we took it to 0 and say until further order of the court or the court deems that the backlog created by the pandemic has been alleviated.
I love
60 days.
I love how little faith you have in this, Pat. Like you're just defeated on the issue. You're like you've come up with 6 ways they're definitely not bringing this thing back, and you could be right on all of them.
If here's the part that I think is hardest for them to swallow. If they brought it back, it could help defendants.
Oh, that is the whole problem.
Somebody might get to enjoy the right granted to them by a statute to their benefit, and they're a defendant in a criminal case. And
Oh, yeah.
we cannot under any
You can
circumstance
never allow that.
allow that to happen.
ever.
I'm laughing because it sounds very true.
And I think they all but said that. I mean, that's all but what was said in that order.
Yeah, this is at this point, this is a gigantic mess that they created by 3 ridiculous orders and not having an exit strategy, or maybe they had an exit strategy at the time and we don't know what it is. But there's not an easy way to deal with this at this point. The cases are so backed up that I think they either end up looking really bad or it doesn't, or they're putting a ton of pressure on the state, which we know they really don't like to do.
I think they probably figured a lot of them were going to get alleviated by the pleas of inconvenience that we just talked about. You mean to tell me I'm going to sit here until I take their shitty deal or I have a trial and there's no telling when my trial is going to be?
Well, and that's
Fine.
that's the perversion that the civilians don't understand. The perversion is exactly this. You're arrested for doing X. You're arrested, and let's just say that your average time to get that case to trial based on the system that you're in is 90 days. But the problem is that charge X only carries 30 days.
Yeah.
So there you sit in jail for 90 days waiting to serve your maximum 30-day sentence. That's the problem. The problem is the reason that we have speedy trial rights isn't because we love to let defendants go or we love defendants or we're super liberal. It's none of those things. It's because if you're going to have a system with set penalties, if you're going to hold people past that set penalty before you even decide whether they should get that penalty, you're running a very perverse system. That's why it's there.
You know what? And maybe you guys haven't accrued the backlog I have, and I made some efforts early on to try to work stuff out, and then said screw it. But
Hilarious, Pat. Hilarious.
What's funny here to me is like you see how important the threat of a trial is, not for an individual defendant, but for the integrity of this entire system, because you've taken the threat of a jury trial away. And it's caused a huge backlog. Like it shows you that state's attorneys are not on their own trying to come up with what they know is what a case is worth and move it. Unless they're forced through the threat of a jury trial, like the system breaks down. And when you want to talk about, we've talked about the number of trials going down in the last 10 or 20 years or whatever. I wonder how much of that is directly attributable to this idea that the system is now kind of discouraging trials where it probably didn't 30 years ago. I mean, this is huge. Like you look at it from this standpoint, this entire system is based on trying to discourage people from having trials. And when you like, now they're not even really eliminating that threat, they're just pushing it out to the future. It's caused the entire system, I don't want to say it's crumbled, but it's caused the faults of the entire system to be on display and put it in a position where I've been telling my clients, like, when this dam breaks, there's going to be people catching breaks, like great deals. I don't know who they are. I have no control over who they are. It's probably going to be completely random, but we're putting you up in that queue and maybe you catch a break. And it's actually a little bit disgusting when you talk about the added ethical, I guess, requirement of a prosecutor to do justice, how little it is from their end about saying, well, this is ultimately what the judge is going to do in this case. I'm going to offer something a little bit sweeter to move it along. That's just, it doesn't factor into their thinking, or we'd still be moving a lot of cases, and we're not.
I'm going to set, I have 2 18s that are left that are up tomorrow, a ton of 19s and some old 20s. I'm going to set 22 cases for jury tomorrow in 2 courtrooms.
I love it.
One day.
I love it.
I bet we've set.
Don't pick any of my days. Don't
Well,
get
Ray,
anything in May.
But
Ray,
here's the thing, Pat, and let's get back to what you said earlier. You're going to set 22 that are going to be scattered on 4 or 5 different days, maybe 6 days.
Mm-hmm.
You're going to be telling your clients, hey, there's probably going to be 50 cases set for trial that day. Don't get too excited about your right to trial. That client's going to show up at a pretrial. On that pretrial, the judge is going to say, Mr. Walsh, this guy's number 11. Come back in an hour, we'll see where you're at. Okay, we've got 10 ahead of him. Mr. Walsh, I'm going to give you another day, three months out. You're going to say to your client, got to be here at a pretrial in 3 months. But to be honest with you, they're so backed up, I don't know if we're going to get a trial. I have a 2018 DUI that I have answered ready for trial on, picked part of a jury on at one point, like 4 times already. And I just keep getting bumped. And that the incentive there is not to put your guy in a position where he can wait it out and go to trial. The incentive there is to grind your guys down of those 22 and put them in a position where they take a compromise deal, right?
Yep.
One of the cases is up tomorrow is the one that I was, they deliberated on for 11 and a half hours on June 1st.
Yeah, there you go. And mine's up next week, and it's separate trial again. Obviously not going to go, but it's going to get pushed out.
God help that young lady if there's 2 in custodies that need trials. Guess what? We'll see you in June.
And I think I could be wrong, but I think both our clients in that situation were licensed professionals. My clients received a letter from IDFPR already, and it's like we have incurred 0 delays. We've showed up several times and said we're ready. And I text her occasionally. I texted her recently and said your next court date's not going to go to trial, and I can't tell somebody now if you give them a trial date in June and they're going to have a trial. So whatever.
Well, and she's going to go through it now that we're starting back up, again. She's going to have the trial in the same effed up configuration that led to a hung jury last time. So we're 8 months, 8 months farther down the tracks. We will be ultimately by the time we get there. And we could be dealing with the same thing all over again. Her lot in life has not improved at all.
Gentlemen, I'm so glad that you've provided answers to those questions. You provided solutions to pressing problems that we have, and you really have pushed the law forward in your discussions. You really have done a great job. But tonight,
I'm proud of us.
Tonight, we're not getting paid any extra for doing overtime. So good night, YouTubes. I hope that I hope that you've enjoyed the dire discussions about how poorly our system